My name is Karen Speyer, and I am the Regional Network Coordinator for the Family Support Institute for the Fraser South region. Before we get started, I'd like to personally acknowledge that I'm coming to you virtually from the Coast Salish lands, the unceded territory of the Katzie, Kwantlen, and Semiahmoo First Nations, today known as Langley. I'm very appreciative to be able to work and play on these lands. For those of you that are not familiar with the Family Support Institute, we're a nonprofit society with our provincial office located in New Westminster. We're a network of trained volunteer resource parents throughout the province that all have a family member or a child who lives with a disability, diagnosed or not. It was my youngest son, Kevin, that brought me to the Family Support Institute 24 years ago now, and our peer-to-peer support model was incredibly helpful to me and my family. We are we're very unique in Canada in that we're the only grassroots organization that provides family peer-to-peer support. All of our services and supports are free to any family across the country. And we feel that by sharing our lived experiences that we really are able to pay it forward, so to speak, and provide that peer support that so many families need. If you'd like to learn more about the Family Support Institute, put into the chat box our website and our contact information in order for you to be able to look at many of the wonderful resources that we have. So before we begin our session, and I introduce our host, Bob, who will introduce our speakers, for those of you who may not be familiar with Zoom, which we know we've spent many hours on Zoom, if you'd like to ask any questions, you can put your questions in the chat box, and you would do that by hovering over the little chat icon, and we'll be copy and pasting those questions so that you'll be able to ask them when the time is appropriate. Or if you like, you want to show some reaction, you can just hover over the reactions button and share your experiences there as well. So without any further ado, I'd like to introduce my co-host and co-worker, Bob Kashup. Bobby Taylor is also assisting us from FSI, but Bob, over to you to introduce yourself and our speakers. So thank you very much.
Thank you, Karen. Good afternoon, everybody. My name is Bob Kashup. I'm a staff member at FSI and also a parent. I'm the Provincial Coordinator for Family Support, and I'd like to welcome you to this excellent presentation that we're going to see with our guests, Ken Kramer and Audrey June. Ken and June have been extremely gracious with their time in supporting us host these fantastic information sessions. And today we'll be talking about the representation agreements. Just an introduction to our guests. Ken Kramer is the founder and principal of KMK Law, a boutique law firm in downtown Vancouver. There's a lot on the screen that you'll see about Ken, so I won't go into those details, but all I can say is that we are really fortunate to have Ken with us today to help us get a better understanding of representation agreements. And of course, accompanying him is Audrey June, who's also an associate at KMK Law, and she combines her legal background with the grounding in public legal education to bring a unique perspective to her practice. So like I said before, we are really grateful to have both of them present at today's session. And I will now hand the reins over to both Ken and Audrey to take us through this wonderful afternoon. Thanks so much. And Ken, I hand it to you now.
Great, Bob. Thank you so much. And a pleasure again to be able to present to members of your wonderful organization. And Audrey and I are always very happy and pleased to present to your network and your families. So I'm honored, and we're both very, very pleased to be here today. Bob and Karen, as you had outlined earlier, we are obviously very much open and eager to answer questions. And I know there's always great questions in these sessions. And so we really welcome those. I will say, though, that because we've done a lot of these sessions over the years, we obviously are trying to anticipate questions that the audience may have. And so there may be answers to your questions throughout the presentation. And if we politely ask you to hold on, we might just sort of pause at certain sections of the presentation. And Karen and Bob are always great at sort of keeping track of those questions so that we can respond to them. I will add as well that this PowerPoint is going to be made available to everybody. And within the next day or sooner, perhaps, we'll make sure that the materials are sent out, so everybody has that. So no need to take notes. The materials will be there for you. Okay. So let's begin. I always think it's great to have some understanding of what are the learning outcomes and what are we trying to achieve today. And really the big focus today is around personal planning. And we'll touch on what personal planning really means. But ultimately, we're going to spend some time talking about representation agreements and how they differ from powers of attorneys. Within representation agreements, we're going to discuss the differences between a Section 7 and a Section 9 representation agreement. Fundamental to any planning is the importance and relevance of capacity and the ability to develop these personal planning documents. And then we're going to spend a little bit of time on what is private comiteeship and what does that involve. And really a lot of the emphasis today is around developing learning so that families can take steps to really avoid the need for private comiteeship if possible, because it is a last resort sort of vehicle. So, and again, on the personal planning sort of discussion, I think the first fundamental thing to be aware of is that when we're talking about personal planning, we're talking about documents that are created while you're alive, and that they will essentially die with you. So when you pass on, these documents are no longer valid. And so those traditional personal planning documents, as I outlined a little bit earlier, are the representation agreement, the enduring power of attorney, advanced care directives, and a host of other documents that provide more focus on personal planning. We are not going to spend any time today on estate planning, which is, documents that are created and take effect upon death. And these are what we call the wills and other estate planning documents. We did a session last week on estate planning and trusts. So this focus of today is on personal planning. So one of the fundamental components, as I'd said, to developing personal planning documents is that there's this presumption that everyone has capability to make decisions when they turn 19 years of age. And of course, we know that that is not always the case. And there are a host of reasons why capacity may not be in place. Capacity as well is a transaction-specific development, and it's general, and it really is tested based on the nature and effect of the decision that is being made. Again, some individuals may never have been considered capable under the law for these specific transactions, and others may lose that ability over time due to aging, disease, or accident. And I think this is really relevant for families that have minor children that they've always had sort of the ability to sort of manage and have responsibility for their affairs. And then when that age of 19 comes across, they're now adults. And of course, there is this presumption that they have capacity to make decisions. So I think it's really, really important from the standpoint of, dealing with and managing the affairs of people with various disability and predominantly developmental related disability. So there's a number of tools that we could look to plan for incapacity, end of life, or overall support needs. So I'm going to spend a little bit of time initially talking about one of those tools, and this is commonly referred to as an enduring or a power of attorney. Again, this is a document that is only utilized while you're alive. Again, it is not effective after death. So when you die, the power of attorney dies as well. Now, in terms of attorneys, individuals that you appoint or persons to be your attorney, these are individuals that you can appoint in your power of attorney to help you make legal and financial decisions on your behalf, even if you later lose that mental capacity. Now, one of the requirements of a power of attorney is that there is a need for a high test for mental capacity. You must understand the nature and consequences of developing a power of attorney, of appointing an individual or individuals as your attorney. So it's possible that this document may not be available or utilizable for family members where there may be a diminished level of capacity. And it may be that this document is really intended for folks that have that requisite capacity to appreciate and understand what it means to delegate or appoint substitute decision makers for purposes of legal and financial affairs. So there are a number of different types of powers of attorneys, and really they can include broad powers, to handle financial and legal affairs, while the individual that grants that authority has full capacity, and even when they become mentally incapable. Many of us have probably seen financial institutions that have powers of attorneys in place within their organizations that might be more task specific. You may have powers of attorneys that are only relevant or in place for a certain time period, or for managing property, for example. And then the enduring component is, includes those broad general powers, but it does not end if the donor, that is the individual making the power of attorney, becomes incapable due to illness, disease, or accident. So they effectively endure from the point of having capacity to a further point where capacity is not in place. And then again, at the point of death, those documents no longer have any validity. So it's obviously really important for individuals that have assets or significant assets. And the one that comes to mind most commonly is where, a husband and a wife own, let's say, property in a joint tenancy relationship. This is where, if one of the spouses became incapable at a later point, the other party with a power of attorney would be able to manage that asset and manage the financial affairs of the spouse that has no longer got that capacity. Without the power of attorney, an unfortunate result could happen whereby the other spouse with capacity may need to apply to court to be appointed as a private committee to manage the affairs of the incapable spouse. And we'll talk more about private committeeship a little bit later on in the session. So many individuals will also ask, who can you appoint as your attorney? And really, there are not really specific restrictions. You could appoint a spouse, you can appoint children, friends, or other relatives. You may even appoint a trust company, a financial institution, a professional person, such as a lawyer. I guess the one criteria that should be recognized is that, it's likely that a professional attorney will charge fees for that service. So that could add some costs to assuming that responsibility. But generally speaking, anybody that's appointed as an attorney has an entitlement to assess whether or not they're going to have fees. And so fees are always going to be a reasonable expenditure for acting as the attorney. So within the power of attorney legislation, and I think this really is where the emphasis on choosing an attorney is so important, because there is, in fact, a very high level of responsibility and fiduciary oversight. And you can see here the legislation, Section 19 of the Power of Attorney Act, sort of outlines the extensive list of duties that is the responsibility of that attorney. So it is definitely not an honor to be an attorney. It comes with a great responsibility, as well as significant risks and potential liability if you have not acted prudently as that attorney. And so I think just, making sure that your attorney is aware of the duties that they have is so important before they actually are considering taking on that responsibility. Now, Karen, before we move into representation agreements, I'm wondering, are there any questions about powers of attorneys?
I'm unmuted. We have a few questions, Ken, not particularly around that topic, but we do have one with regards to varying levels of capacity. So interested in understanding the varying level of capacity being accommodated?
Yeah, I mean, I think the one thing again to remember is that capacity is specific to the transaction at stake. And I think that's a question that comes up a lot because, when we're talking about, what is the requisite capacity to, say, undertake the development of a power of attorney or a will or, a representation agreement, it needs to be specific to that transaction. And generally, capacity is not necessarily a medical test, although medical evidence will be beneficial and helpful. But ultimately, it's the lawyer's decision. It's the lawyer's responsibility to develop confidence that the client who wants to develop a document appreciates and understands what that document is. What does it mean? What does it not mean? And as well as what is the impacts of creating that document? Does the individual appreciate what their assets are? Can they recall what their assets are? Can they appreciate what it means to appoint person A versus person B? Are they comfortable and aware of what it means to develop a power of attorney versus a will? So the element of determining capacity is not an easy answer question. It's one that involves dialogue between the lawyer and the client to develop confidence that they have the ability to develop one of those documents. So, when we look at the circumstances, we'll go through an interview process to develop confidence that the individual has that legal capacity to fulfill the tools or the requirements of developing that document. But I think it's really important for the audience to remember that, it's not necessarily a medical test. And we're not doctors, obviously. We're legal professionals. And our job is to assess this from a legal sort of perspective, recognizing that medical elements will potentially play a role and may help support, our legal sort of decisions. But, we have an ultimate responsibility as lawyers to assess capacity from that context.
Thanks, Ken. We did have a couple of mailing questions prior to the session from folks that were not able to attend. One of the questions was, my daughter has a disability and going to get PWD, and I believe something was said to get her a representation agreement. Is that not the same as power of attorney, as I am confused? If you could clarify, that would be great.
Yeah, so I'm going to hold that question because Audrey is going to answer that, I think, in the context of representation agreements, and that will provide some better clarity, I guess. Generally speaking, there's some fairly significant differences between these documents as well as capacity, and I think once we get through the representation agreement portion, some of these questions may be answered in themselves.
Great. I do have one more question on power of attorney. For power of attorney, is there a recommended scale for remuneration by, say, a law society, et cetera, or is it just up to the parties involved?
So where compensation is silent, there is a provision within our trustee legislation. So attorneys are, in fact, trustees. And so where parties have not put their mind to issues of compensation, trustee legislation under the Trustee Act of BC outlines what that compensation might look like. And generally speaking, there is the entitlement to an upfront capital fee, which is a percentage of the estate based on the complexity of the estate that's being administered. But there is also an entitlement to an ongoing annual care and management fee that is also legislatively outlined in that legislation. Now, that doesn't mean that those maximums that are permissible are what is considered reasonable. It will depend on the complexity of that estate and the actions of the attorney in managing the individual's affairs. And individuals definitely have the ability within the power of attorney to outline a fee structure as well. And so I think it's a great thing to be discussing, with your lawyer when you're developing a power of attorney, to put your mind to compensation so that you're comfortable, but so is the attorney. And I should also add that any income earned in that capacity by the attorney is also going to be taxable as income. So that's something to be mindful of, because if you're already in a high income bracket and you add more income, you're going to be paying also more taxation. So taxes are a relevant issue as well if you're an attorney and you are assuming or seeking compensation for that role. Many corporate attorneys and professional attorneys will have fee agreements that they will have you sign and enter into before they will act as an attorney. And generally speaking, the fees of those documents or those entities are going to be higher than the average person.
Great, thanks, Ken. One more question on power of attorney, and then I believe we can move on. Can a parent be a power of attorney?
Yeah, I mean, again, anybody can be an attorney, assuming that they're over the age of 19. But remember that it's the individual that is granting the power of attorney that ultimately must make that decision. And that individual must have capacity to develop one of those documents. Okay?
We do have other questions, but I think they'll be answered in the next session.
Okay. I'm going to turn
you.
things over to Audrey, and she's going to now run through the representation agreement and some of the distinctions between the different types of representation agreements.
Great, thank you, Ken. So in BC, we're actually really lucky. We have legislation called the Representation Agreement Act, and that's actually very unique across Canada. So I know one of the questions talked about capability, and what this law recognizes is that even though some adults might not be capable in the traditional sense, and when I say traditional, I mean things like being able to make a contract, and even making a will have potentially a higher capability requirement. And even though these people might have their mental capability be in question, they may still have a way to appoint persons they trust to help them with decision making. So for people such as myself and most of the audience here today, likely, we would be able to make something called a Section 9 representation agreement, or for short, I'll call it the RA9. So with this RA9, I can appoint people to help me make decisions or to make decisions on my behalf regarding almost all healthcare and personal care matters that that I can give someone to help me make decisions on. But I need to be considered mentally capable of understanding the nature and effect of the Section 9 representation agreement when I make it. On the other hand, for individuals whose capability is in question, for example, adults who may have special needs or an intellectual disability, or an adult who has developed advanced dementia or had a stroke, even though their capability might be in question, they may still have the ability to make a Section 7 representation agreement, or a RA7. So the RA7 has sort of a broader definition of capability. And if you look in the legislation, the way that that capability will be determined is if, for example, the adult has a relationship of trust with the person that they want to appoint. They can, for example, show preference in choosing one thing over the other, or they can, for example, say essentially like, I trust mom, I want mom to help me make decisions. So there's sort of criteria like that to help you decide whether that person has the capability to make a Section 7 representation agreement. And what the Section 7 representation agreement can allow is to have the adult making the document, to give the people they trust the legal authority to help them make decisions in all life areas. So not just healthcare and personal care like the Section 9, but also some financial affairs and some legal affairs. So this next slide is about sort of what can these different documents authorize. If the Section 7 can cover all 4 areas of life, why would you make a Section 9? So again, if I'm making a Section 9 for myself, I'm likely going to make it together with an enduring power of attorney. So the enduring power of attorney, which Ken talked about, covers me for financial and legal affairs in the broadest way possible, while the Section 9 representation agreement is going to cover me for my health and personal care matters for the broadest total coverage. So with the RA9, in addition to minor and major health care matters and personal care matters, I can also authorize my representative to refuse care for life-saving treatment or care, to give or refuse consent to some specialized medical procedures. And if I have children, I can also authorize them to make arrangements for the temporary care of my minor children. For example, if I'm hospitalized for a long time. On the other hand, somebody who's looking at making a Section 7 representation agreement, this is likely only going to be a situation where they can't make an enduring power of attorney or a Section 9. So the ideal scenario is somebody making an enduring power of attorney in Section 9, because again, that's going to cover the broadest range of powers possible. But what the Section 7 does is it does cover routine financial affairs and some legal services. For example, with the RA9, the adult making the agreement can authorize somebody to help them pay their bills, to set up an RDSP for them, to communicate with Canada Revenue Agency, to instruct a lawyer to defend a legal proceeding against them, arrange for dental visits, consent to medications, and also make decisions about living arrangements. So there are some limitations of the representation agreement. You might have heard of MAID or medical assistance in dying. We'll briefly go over this later, but in short, you can't authorize anyone using any document to make a decision about medical assistance in dying on your behalf. It's also a bit out of scope of this presentation, but I just wanted to make that clear. Also, just a friendly reminder, the Section 9 does not deal with money, financial, legal affairs at all. That would be the enduring power of attorney. And with the Section 7 representation agreement, I talked about some limitations. So with the Section 7, you can't authorize your reps to deal with real estate, real property, and you can't also authorize specific healthcare decisions that you might authorize in a Section 9 representation agreement. I won't go through all of them. If you are interested in the specific ones, we'll list some resources at the end of the presentation where you can go and sort of read more in depth. But just be aware that it's just not as broad as Section 9 and the enduring power of attorney put together. So Section 16 of the Representation Agreement Act provides a good overview of the duties of a representative. So on the slide, I've pulled out a few different points here. Representatives generally have a duty to act honestly, fairly, and prudently within the ambit of the authority given in the agreement. And they still have a duty to consult as much as reasonably possible with you to determine your current wishes. And if they can, they must comply with those wishes if it's reasonable to do so. So essentially what it's trying to say is, if you're still okay, like if you're still, there with them, you're not in a coma or anything like that. Appointing a representative doesn't mean that your powers are taken away. It's just that they're there to support you when you need it. So depending on the situation, they must comply with wishes or instructions you expressed while capable. And even if that's not available, let's say you are in that coma, they must still act on the basis of your known beliefs and values, and as a last resort, in your best interests. And again, like the...
Hello, Karen speaking.
Oh, sorry, Karen. I think you're unmuted, Karen. Oh, there we go. Okay. And just like Ken mentioned about the attorney, and being a representative is not necessarily an honor. They do have duties. They have a duty to keep accounts, to keep records regarding the exercise of their authority. For example, you could do this in a journal or notebook to write down dates, describe circumstances, and list people involved. For example, a medical professional who might have been there, the decision you made as a representative, or action you took and why. You must also, as a representative, keep copies of records the adult made of their instructions, wishes, beliefs, and values, and a record of changes to where they live, whether you authorized any decisions about moving them, for example, to a different care home. And if you're appointed in Section 9 or Section 7 representation agreement, and you're also dealing with financial matters as a representative, you must also make reasonable efforts to keep records of their assets and liabilities. For example, their bank statements, their receipts, bills, those things that you managed on their behalf. So how do you make a representation agreement? So there are a few different things that you need to do. So for example, the adult, which is the person making the representation agreement, the representative, at least one is required. There might be multiple that may act independently or together. There might also be, in the case of a Section 7, someone called a monitor. They must all sign the agreement. Just a quick note on the monitor. Some people had a question, often have a question about, do we need a monitor? The monitor is really there if in the Section 7 you've provided for financial powers. So if you have financial powers, you generally need a monitor unless you've appointed more than one representative who must act together. And I believe also if you've appointed your spouse, the monitor may not be required. But again, if you're concerned about that, it is listed in the resources at the very end. The adult must also sign in the presence of two witnesses, unless one of the witnesses is a lawyer or a member of the BC Society of Notaries. There's also, for example, an option for somebody to sign on behalf of the adult if they're physically incapable. However, the adult must still be physically present and direct that the agreement be signed on their behalf. There are also important restrictions to note on who may act as a witness. For example, the witnesses must be adults. They can't be, somebody named as a representative in the agreement or their spouse, child, or parent. There's also some restrictions on witnesses being employees, not witnesses, representatives being employees of a facility where the adult lives and receives care services, unless they're the adult spouse, parent, or child. Something else to note is the representatives actually don't have to be present or sign at the same time as the adult. The only persons who are required to be together at the time of signing are the adults making the agreement and the witnesses. However, if the representatives are signing separately, they must sign after the adult. Even though they don't need witnesses, they must ensure that the adult and the witnesses have signed the agreement before them. Then they can do something called signing in counterpart, which means they can sign on a separate copy of the page on the document that asks for their signature. So that's helpful, for example, if you have the adult living in Vancouver, but we're in COVID lockdown and they can't travel to like Whistler or something like that, and the representatives are in Whistler, then you could mail them the document after the adult has signed it, and then they can sign in counterpart there and then mail it back. So there are a couple other documents that I believe Ken mentioned earlier in the presentation. So you may hear the term advance directive. And what that is a written document. So you're not appointing anyone in the advance directive. It essentially says that you give or refuse consent to specific healthcare matters. So the advance directive is actually quite rigid and limited in its use because your instructions have to be explicitly clear and clearly applied to the specific healthcare situation that arises at the time that consent is sought. So that's clearly not very flexible because, we can't see into the future. We don't know what's going to happen. Like, 10 years ago, nobody would have expected that we'd be living through the COVID-19 pandemic right now, and something that an advance directive somebody may have made 10 years ago might not clearly apply to any situations that arise today. And that's why we generally recommend that a representation agreement might be better, because the representative can, react to and recognize the changing circumstances as they happen. So a representation agreement actually supersedes the advance directive if somebody has made both. However, you might state in the representation agreement that the healthcare provider may act in accordance with an instruction in the advance directive without the consent of a representative. So that is always an option. Sometimes people also ask about organ or body donation. So donating your organs for research or education purposes. So a consent is required for that, and you can register your wishes with BC Transplants Organ Donor Registry. And thirdly, as we mentioned previously, medical assistance in dying is outside the scope of our presentation today, but just briefly, currently in Canada, physicians and some nurse practitioners, depending on province, can provide medical assistance in dying services while strictly following both federal and provincial laws. No one can be forced to provide or to help provide MAID, and in order to be eligible, there's very strict requirements. You must be at least 18 and mentally competent or capable of making healthcare decisions for yourself. You must have a grievous and irremediable medical condition, and you must make a voluntary request for MAID that is not the result of outside pressure or influence, and give informed consent to receive MAID. And you can't create a planning document that authorizes somebody else to request it on your behalf. So we've talked in the past few slides about enduring powers of attorney and representation agreements, which are really planning tools that you can use to avoid committateship as much as possible. So committateship is when somebody is appointed by the court in the province you live in to make decisions about potentially all of your affairs. It's quite an invasive process, and it's considered a last resort measure when you've really exhausted all other avenues. You may also have heard of the term adult guardianship or statutory guardianship. So that's the term used when the public guardian and trustee, which is a public and government body, takes over the financial and legal affairs of somebody after medical assessments are done, and a certificate of incapability is issued by the health authority. So that's a statutory power, which means it's from the legislation rather than through the courts. And that's usually when the public guardian and trustee determines that somebody is incapable and needs help and nobody else is available to help you. So who can be a comité? So we mentioned the PGT, but let's say you haven't planned. So you've not made a representation agreement, you've not made an enduring power of attorney, or you're unable to make either of those documents, or the Section 7 representation agreement is insufficient for some purpose. For example, you have real estate you own and that needs to be sold to pay for care fees or something like that. So like your family and friends have exhausted all avenues, and you really have to get something to deal with this real estate. So what happens is a family member or a friend, really anyone, can apply to the court to become your comité. So this procedure is not ideal. It's quite expensive. It can cost thousands of dollars. Again, if there's no one able to act, let's say the public guardian and trustee receives reports that you're living alone, somebody is potentially financially abusing you, the public guardian and trustee, the PGT, might actually step in and ask for an assessment from a qualified healthcare provider and start that guardianship process. So should the commutation procedure have to be undertaken, there are several steps involved, and it includes the following steps. So you need 2 medical affidavits. So you need 2 physicians to swear an affidavit. So they need to share their opinion that the patient, so the person who's being applied for to get commutation over, is not capable of managing their person and or estate. Oh, sorry, there's a typo on the slide. It should say incapable, not capable. So the physicians may charge fees for this service. So it can range anywhere from $300 to $2,000. There's a vast range for physician affidavits. The applicant, so let's say you're applying for your family member, you have to swear an affidavit providing personal information about the patient. So it can actually be quite thorough. Not only do you need to list their age, but also their living arrangements, their income, assets, expenses, liabilities, and if you're applying, you have to list your qualifications to act as comité. You might also need to provide an outline of a care plan for the patient. Again, this depends on what type of commutation you're applying for. There's 2 types. So comité of estate, which means you're managing that person's finances and legal affairs, and comité of person, which is more the healthcare and personal care side. Once you're
Audrey, can I just interrupt for a second?
Of course.
I should have jumped in a little earlier after the representation agreements. I wonder if we could maybe just, before we go any further on commutation, if we could just touch on, Karen, if you have any questions about representation agreements. I know there's a lot of information there, and maybe we could let Audrey take some questions on that first.
Thanks,
Sure. We do have a fair number of questions. One, and perhaps Audrey, if we can get some questions answered, I might actually send you the questions so that you can send them back to me for these people that are not in attendance today, because we did receive a few mail-in questions.
Okay.
So the first question was what I mentioned earlier about her daughter has a disability and going to get PWD. I believe something was said to get, hold on, I need to just make this a little bit bigger. Get her a representation agreement. Is that not the same as power of attorney? I believe that question was answered. The second question is, we have a Section 7 rep agreement in place for our now 28-year-old son for several years. Is there anything else we need to put in place to ensure his future care and legacy are taken care of? If he does not have a will, and I understand that is not possible, what will happen to his asset when he dies? So I believe this, Ken, might have been more appropriate for last week's sessions. Is it necessary to have a guardian appointed to avoid problems in the future for any reason?
Sorry, Ken, did you want me to take that one, or?
Yeah, go ahead, Audrey. Yeah, absolutely.
Okay, I just to clarify, so this person has a representation agreement, I'm assuming is Section 7 for their son, and they're wondering what's going to happen to their son's assets if he can't make a will, and is guardianship necessary?
Right.
So again, just to preface all of this, and I think this is going to be a common disclaimer, is that you know, we don't know their situation and what they're dealing with and what's going to happen in the future. But again, if capacity is at issue, it sounds like with a seven section representation agreement, they're off to a good start, because that can help you, you know, manage your son's affairs. If he has PWD and also the disability tax credit, he might also have the opportunity to open a RDSP. And so the representation agreement Section 7 will help with that. So that facilitates things like, you know, continuing to take care of them, to do basic financial transactions for them, to do their taxes for them, things like that. If they die without a will, we have something called intestacy in BC. And what that means is that your assets will be divided according to the legislation that the government has put in place. So generally it'll go mostly to your spouse, and if not your spouse, your children, and then it goes in sort of order of, you know, next of kin, grandparents, grandchildren, and so on and so forth. So that's essentially what happens if somebody can't make a will. Whether or not they need guardianship, you know, a lot of people get through life without needing guardianship, especially if that person doesn't have a lot of assets, so they don't have real estate or anything like that. That's not to say that a situation can't come up later where guardianship may be needed for some reason, but you know, we can't comment on the future. And again, commutation is quite an invasive process. It's very hard to go back from that. So that's really a last resort option. So we would generally not encourage families to go to guardianship or commutation unless it's absolutely necessary. And again, you know, we would really recommend getting legal advice at that point when you're potentially considering that as an option.
Great, thanks, Audrey. Next question is, do you need to have an RA7 as well as an RA9?
So I think I kind of answered that. So the difference between the RA7 and RA9 is that if you're capable of making an RA9, which I think most of the audience is here today, you would not have to make a Section 7 representation agreement, most likely, because you'd be making a Section 9 representation agreement for your healthcare and personal care matters, and you'd be making an enduring power of attorney for your financial and legal matters. And so the Section 7 is really for those individuals who don't have that traditional definition of capability. So they might not be able to make a contract, they might not be able to manage their own financial affairs, they might not be able to make their own healthcare decisions, but they're still able to, for example, display trust in another individual. They're able to show preference for one individual over the other, and they're able to say that I would like this person to help me make decisions. So the Section 7 representation agreement is sort of an agreement that confers powers on the representative that they appoint, but they're not as broad as a Section 9 or an enduring power of attorney.
Thank you. Next is a question. I have an RA7 with my adopted son's birth mom. Just had a meeting with her, and I'm very concerned about her mental health as well as her health. How can I help her?
So the birth mom, is the birth mom the adult? So they've made the representation agreement, and the person asking the question is the representative.
Wendy, would you like to comment on that?
Okay.
Yes, I can. So we made this agreement some time ago, and when I recently met with her, her mental health was, mental health is not good at all. And I don't know if there's anything I can do to help her. And I know she feels that she's fine, absolutely fine, but she's not. If there's anything, can I do anything to support and help her if she doesn't want the help?
That's a tough one. Ken, did you have anything you wanted to?
Yeah, I'm happy to jump in there. It's a great question, Wendy. I think that, the starting point is to recognize that whether it's a Section 7 or a Section 9 representation agreement, the starting basis for these documents is that they are supportive tools. They are not initially substitute tools. And so when an adult is, able to express wishes and make decisions, ultimately healthcare providers, and in this case, we are talking about a Section 7 agreement, which effectively provides support with respect to routine financial and healthcare decision making. But healthcare providers and those that are overseeing financial affairs need to recognize that ultimately the adult makes decisions unless they require support, or there comes a point where their capability is not in place, whereby that document, that Section 7 agreement or that Section 9 agreement really turns into more of a substitute decision maker. And that's always a fine balance, because, how do we know when that individual has now moved from having capacity to not having capacity? What is the triggering mechanism that moves us into that category? So it's not a neat and easy answer, unfortunately. And obviously the document itself is important, how it's written, what it says about sort of supporting the decisions when there is potentially, even a triggering of capacity. Is it based on an assessment by someone providing medical oversight? So it's probably a much more involved answer than we're going to be able to offer in terms of justice. I think from your perspective, Wendy, I think that number one, you have a certain role to play in supporting this individual's financial and health from a routine perspective. And, that's something that needs to be reflected on. And obviously, I think what you can offer is support for the individual in making decisions, while at the same time, respecting that that individual ultimately has certain rights and autonomy over their affairs. But clearly, where you get to the point where there may be true capacity issues, that representation agreement may then trigger into a supporting tool where there is a declaration from, let's say, a physician that states clearly that, this individual does not have, or I'm not comfortable that this individual has that authority or the ability to make decisions about their routine financial and legal affairs. I think that, one of the uniqueness of the representation agreements is that, it's really intended to build support around individuals making decisions, and for them to feel confident that they have somebody that they can trust and rely on when decisions are needing to be made, but also that understanding that at some point they may have to make decisions independently of the adult if they've lost capacity. So I think, our discussion just around the grayness of capacity and the fact that it's such a difficult legal term to really understand and appreciate is important as well. And before we actually, engage other medical professionals in the determination of capability, we want to give it the benefit of doubt to the individual that they have capacity, and maybe, you know, encouraging your activity around decision making is a really good starting point.
Thanks, Ken. Just a couple more quick questions. One from Abigail asking, do I need to set up an EPA, enduring power of attorney, for my disabled son aside from a representation agreement?
So again, you, the individual that is setting up the power of attorney, would be the son. So it's not the parent that is setting that up, it is the son. If the son has capability and is able to, you know, justify to a lawyer that they have capacity to develop that document, then absolutely it may be a feasible document. It's hard to say whether it's necessary because I don't have enough information about the individual, about their financial affairs to really be able to say that. But, you know, it starts with the premise that it's not the parent that is making that decision. It is the individual that is granting the power of attorney that needs to make that decision. So, you know, move away from thinking about the parent to the individual that is looking for support in financial and or healthcare decision making.
Right. So she mentions that he does not have capacity. So definitely the RA7 would be
one of the best options available, perhaps, because of diminished capacity. Definitely. So, you know, if capacity is not in place, then clearly a power of attorney where there is a higher requisite of capability would not be potentially a feasible vehicle.
Right. Just two more have just come in quickly.
Great.
Carol Ann, and I'm not sure, Carol Ann, if I'm going to express this properly, so maybe you can jump in if I don't. It was earlier on in the conversation, and she said, so you're referring to a state that is the assets of the individual under care, and she's currently the power of attorney for an elderly aunt. I'm not in the will, and it's a lot of work. Caroline, do you want to maybe just ask your question? Because I'm not really sure I'm expressing this properly.
Hi there. Yeah, I wasn't aware when Ken was talking about estate, I just automatically assumed that estate was when someone had passed on rather than being the power of attorney and taking care of the person's estate. And so that was just there. I was a little bit confused there. And so I just assume now that Ken was talking about the estate of the person when you are acting as a power of attorney. So I am now the power of attorney for my aunt who has become hospitalized, etc. And I just never thought of it in those terms. I also wasn't aware of any legislation around compensation for power of attorney.
Yeah. Yeah, no, Carol, you know, it's a very complex area. And definitely when I refer to a state can be while you're alive or while you're deceased. And ultimately, as an attorney, as a trustee over your aunt's financial and legal affairs, you have a responsibility to manage those financial affairs while she's alive. And it is an onerous responsibility. You know, we outlined earlier on the immense amount of tasks, and it sounds like you're now obviously fully aware of that responsibility and what goes into it. And I think that's a really important element to recognize whenever we're thinking about appointing an attorney, is, you know, that there is some fairly significant work associated and responsibility with that role. And it's important for the attorney to be comfortable with that role and remember that it is not really a task that one should undertake without some really significant diligence, like they would with any business activity.
It's also just reassuring to know that there actually is legislation, so that there's something that will to back up all of my documentation. So I have been awarding myself travel expenses. So my aunt lived in Nanaimo, I live on an island, so there's ferry and gas. And so, I have justification. I have all the documentation, but there's also justification for compensating myself for those expenses.
Yeah, and as well to remember, Carol, that while there is this entitlement to reasonable expenses, it's also important to remember that at some point, an attorney will want to have confidence that their accounts are deemed reasonable, and it's not necessarily the attorney that gets to make that decision. And so we haven't gone into some fairly extensive detail, but an attorney, for example, also has a duty to have their accounts approved by the adult if they're capable. And if they are not capable, then the court must approve those accounts. So when you're assessing compensation or reimbursement, there is ultimately a duty on the attorney to assure themselves and ultimately to protect themselves from potential liability that their accounts have been approved either informally by the adult, again, assuming they have capacity, but if they are not of capacity, then the only way to get your accounts approved is to actually appear in front of the registrar of the Supreme Court of British Columbia and have your accounts approved by the court as legitimate. And then that protects you as an attorney at a later point if someone comes forward, and this commonly happens when the person passes away and now the executor of the estate is managing the affairs, and questions arise as to, were these expenditures reasonable under the circumstances. So Audrey and I could probably do a session just on this topic alone. So it's very, very complex. But I think that the point of the matter is that, again, the roles and responsibilities of that attorney are extensive, and definitely the days of it being an honor are no longer in place. It comes with an amazing amount of responsibility and liability, and it's probably why we're seeing a lot more corporate trustees taking on the role, because the average individual may not have the time or the experience to take on those roles.
Thanks, Ken. So we do have 3 more questions just on capacity. So I'll just put them all out at the same time, because I think you can probably answer it with one question. Is there a minimum capacity threshold for the RA7? For example, if the represented is only capable of parroting back the statement, "I trust mom," but doesn't really understand what this means, can you still establish an RA7? The next piece is there a cognitive delay impeding decision-making? Is RA7 enough? Do you not require guardianship for full and proper care? And the last piece is, does it mean that a representation agreement is different from a substitute decision-making document?
Audrey, do you want to take the first one on just the requisite elements of capability and the test that's within the legislation as well that might provide some guidance?
Yeah, so if you look at the representation agreement legislation, so there's no minimum level per se. So something unique is that it says right off the bat that everyone is presumed to be capable. And something that we encourage as well is that not only can people express their wishes and sort of preferences verbally. Like there are different types of communication. So people might use body language to show trust in somebody, to show that level of trust, to show that they prefer one person over the other. So there's no like clean answer where we can say, yes, this means that this person is capable. It would have to be an assessment by that lawyer in person. But I just want to emphasize the fact that there's no such thing as a minimum level of capacity to make a Section 7 representation agreement, that you should take into consideration all the different ways that an individual can communicate to express their preferences and wishes, and the fact that everyone is presumed capable. So I hope that's a little bit helpful.
Yeah, and I guess, just again, the intention of the Section 7 representation agreement is, again, routine financial and legal affairs. And, the document serves as a vehicle to enable someone with a diminished level of capacity. And Audrey has outlined that that's a very, very broad sort of term. But really the intention was that because we have circumstances of routine, daily banking, where one will reside, very routine healthcare decision making. There was a sense, and just going back over 20 years in this legislation and sort of being at the beginning of all this, there was a real sort of emphasis that, and getting to our other topic of committeeship, that committeeship was just such an extensive intrusion that we needed to have another mechanism to deal with situations where, full-blown substitute decision-making was not necessary. And I think the trade-off is that, we're in this sort of gray area of capacity, but we're also making decisions or supporting decisions that are not necessarily life or death, or decisions that respect, significant financial implication. There are, limits on what can be assisted with in routine financial and legal affairs, and that we need to empower individuals, even where there is diminished level of capacity, and respect their autonomy and their wishes that they have around people around them that are going to provide supportive tools. And so, we're very fortunate, we live in a province where this legislation is quite unique. There is no other comparable throughout the world. We are it. And we really, I think, have taken some great steps to enable those that, may not fit the standard norm of capacity, but to give them an element of empowerment and autonomy and independence around, supportive decision making. And, I think what sort of has precipitated, I think, this presentation is a general fear that families are considering committeeship, and we see committeeship as really as a last resort option, and one that should only be undertaken if absolutely necessary, and that we live in a province where there are these other vehicles that are less intrusive, much less costlier, that offer solutions to empower and provide a good life for those individuals who might need some support in decision making. So it's really why we're having this discussion, is to really ensure that families are aware of the options around personal planning in British Columbia, and that they know that comiteeship is really of a last resort option, and one that may be necessary, but should only be embarked on when it's absolutely necessary.
Thank you, Ken. And I'm very cognizant of the time, so I think we'll hold the questions right there and let you carry on, Audrey, with your presentation.
Great. Go ahead, Audrey. I'll let you carry on with comiteeship.
Great, thanks. So I think I was just going through the application process. I think I was at the third bullet point. So the public guardian and trustee is going to be notified of any comiteeship application. They have to review the application, and they do charge a fee for that, which is currently $525 inclusive of GST. And not only do you need to notify the PGT if you're making an application, you're likely also going to have to notify next of kin, appointed attorneys or representatives, and any agreements that the person might have. If those individuals have a contentious relationship with you, they might submit competing applications. So we did provide an estimate for how much it would cost in the last slide. If you do have a contested comiteeship, however, you will see that fee going up because it'll be a lot more work if different people are fighting over who wants to be the comité. So assuming no contest, the process can take about 3 to 4 months or longer, depending on the circumstances of the case. Generally, the thing that takes the longest is actually getting the two physicians to do assessments of the adult and to find the time to execute an affidavit, a medical affidavit. So that usually takes the longest. So just on duties and responsibilities of a comité, as you can imagine, comiteeship is quite not a fun process, even more onerous, I might say, than an attorney. So they have a duty to act reasonably and prudently and in the best interest, not of themselves, but for the adult for whom they're acting, and that adult may often be called a patient. So the comité is considered a fiduciary, and what that means is they must always place the adult's interests before their own in managing the adult's affairs. For example, when they're making large purchases for the adult, the comité may obtain several prices for comparison or hire a professional person to help them. They must also keep good records and retain, for example, those quotes in the records. The comité also must, to a reasonable extent, foster that adult's independence and encourage their involvement in any decision-making if possible. And when you do make a comiteeship application and the court is making the order appointing somebody as a comité, the court also has the power to put any limits on any of the rights, privileges, and powers of the comité, including needing written consent from the public guardian and trustee before the comité exercises any particular power. So something that's common is, for example, if the adult has a residence, the PGT would need to give written consent to sell that residence. Or if there is a bank account with a lot of money in it, then it's quite common to see needing written consent from the public guardian and trustee before, accessing that account for any particular purpose. And similarly to the other roles, the comité has a duty to keep good records, including hard copies of all statements and documentation of the adult's banking. They are allowed to hire a bookkeeper or an accountant to help set up sort of the comiteeship record keeping, and also to help maintain those ongoing records to be paid out of the adult's accounts. So, okay. So when a comité is appointed, every power of attorney and representation agreement made by that adult is terminated unless otherwise ordered. Again, I think we've emphasized a lot, commentateship is a last resort option. It takes like a very black and white look at capability, whereas with the representation agreement, we have more of a continuum of capability. So, it's not an easy decision. Like you don't want to go out and look at commentateship as the initial option. You want to explore all the different options before that. And now I'll turn it over to Ken, who's going to discuss the pros and cons of commentateship. I think we've gone over some of the points, but there you go, Ken.
Yeah, no, I think Audrey, you've covered it really, really well, and I'll maybe just sort of summarize the pros and cons of commentateship. And obviously, one of the pros of it is that it provides that full protection of the adult, and it's useful if there are some real concerns for the safety and financial security of the adult, and especially where those adults are not able to avail themselves of other planning tools. And of course, there's the additional oversight over the committee of the public guardian and trustee. Now, on the con side, you're now talking about removing the autonomy of that individual pretty much on a permanent basis. They no longer have any sort of ability to make decisions. We've talked about the expense. It can be extremely expensive, to undertake commentateship. And, I would say that, a cost again of well over $7,500 is not unusual. It's going to take time. There's definitely a lack of privacy. Commentateship is an open public forum through our court system. So now the public has awareness of this. So you've lost your privacy. And again, commentateship is something that is very challenging to reverse once it is in place. It requires some extensive evidence to support a reversal of that decision. And as I said, one of the pros of commentateship is the oversight of the PGT. That can also be a con because now you've got a government entity that has a responsibility and role to engage with the committee, and that can add some real complexities where there may be disagreements about what the committee believes is in the best interest of the adult, and where the public guardian and trustee, the government entity, has their own perception. So there's that ability for, even conflict as well. One might question whether committeeship is necessary. And, we have additionally tests under the adult guardianship legislation for the appointment of the PGT, where there is no committee in place, where financial affairs are needed to be managed, and the adult is incapable of making those decisions, and where they may benefit from the appointment and protection of a statutory property guardian. And, the adult may not have any other means of assistance. So, even where commentateship may be necessary, there may not be the willingness of someone to step into that role. And so the public guardian could serve as sort of more of a last resort option. And again, where people have not developed a power of attorney or a representation agreement, that's where this may be a necessity. Now, one of the great things about, the RA7 is that, it serves as a great vehicle when we're talking about, receipt of PWD benefits, federal pensions, CLBC funding, or, routine or healthcare decision making. So comiteeship will not be necessary for those items. And so many of these decisions are decisions that, I think when our children with developmental disabilities reach that age of 19, there's this automatic assumption that I need to have guardianship like I did when they were a minor. But, where we're dealing with, managing, for many families, it's managing PWD benefits or CLBC funding. Comiteeship is really not necessary for those vehicles. So, this last slide here is a really good sort of hierarchy around healthcare decision making in BC. So again, there's that presumption that, you ultimately have that ability to make decisions about your healthcare needs while you're capable. And then, of course, the last resort item of comity of person, where the court determines a representative to manage your healthcare. Now, there are these other vehicles that we've gone through around, a representative being able to assist in managing healthcare, an advanced care directive, if it applies to the specific situation at hand. And then one step further, we have what we call temporary substitute decision makers, or the TSDMs. And these are temporary in nature and really are determined by statute. So when there is nothing in place around healthcare, this legislation ultimately will provide sort of a hierarchy of decision making around healthcare and some criteria for that appointment. So, how do we avoid comiteeship and TSDMs? And, obviously, the starting point, if possible, is make a Section 9 representation agreement and an enduring power of attorney. And that will assist with not only supportive and substitute decision making around healthcare, financial, and legal affairs, but if capability is in question, then we have, again, a unique to BC product, a Section 7 representation agreement may still be available and still provide the ability to legally and directly empower someone to assist or support you in making health and financial decisions. And it will assist in identifying specific decisions that your representative can or cannot make. It also provides that comfort of knowing that you have a representative that must follow your known wishes and belief. And it provides that ability to override these statutory schemes of consent to healthcare by substitute decision makers. It avoids court expenses and the intrusiveness of comiteeship, and ultimately providing the ability to give authority to someone to help make decisions rather than only to make them on your behalf. So again, I can't emphasize enough that supportive sort of element of these documents, not automatically substitute. It really starts with assisting and supporting the individual in making decisions, and then ultimately will convert, if necessary, into a supportive or a substitute tool. this is a bit of a diagram, just, if anybody's ever sort of just wanting to have a look at the different documents and the comparisons about them, money, legal, health, and supportive care. It really provides a good sort of snapshot of what these documents do and what they do not do. So hopefully that will help folks a little bit better understand the distinctions between all of these documents. Finally, I want to just outline that there are a host of resources available to folks. I can appreciate that this session might be a little bit overwhelming and it might take some time to digest this. Our website is full of information, articles that we've written on this topic, presentations that we've given. This session is being recorded and it will be available not only on the FSI website, but our website as well. So you're free to come back and view the recording again if you didn't get everything today. And hopefully it will provide more support. NIDIS, the NIDIS registry, is another amazing resource for families as well. And they've done a lot of work in representation agreements and are a really good tool. Their website is even a resource we utilize on a regular basis. So very, very helpful. And then of course, the Public Guardian and Trustee has a committeeship handbook that will provide a little bit more oversight and information around the role of committees.
Excellent.
Yes, and I believe that is the end of our presentation. Again, thank you, Karen and Bob, for allowing us to present today. We're happy to take a few more questions if you like as well.
Thank you so much, Ken and Audrey, for this amazing presentation. Every time I hear your presentation, I learn something new. We did have a few more questions in the chat box, but I am very cognizant of the time. So I was thinking perhaps I could put an email together and send that to you.
Do you mind, Karen, if we just take the questions?
Oh,
I always
sure.
find it
I just didn't want to
a little
take off. Yeah, no, absolutely.
And we don't mind doing that. I always find it more efficient if we can have a dialogue anyways.
Well, one of the first questions is, can we kindly ask if you accept new clients? So I am sure that we will be getting some contact. One of the questions from one of our participants was, when does one start the process of power of attorney and representation agreements? Age 19, or should it be in place by then?
Yeah, no, that's a great question. I know that many of my families, I don't know if you've heard about this, Karen or Bob, but many families will have a Section 7 representation agreement party on the 19th birthday, because that's when you go from minor to adult. So that would be the time that I would suggest at a minimum that a Section 7 agreement is in place. If you're looking at developing a power of attorney, that's probably where you would want to involve a lawyer or a notary to assist in that process. And then again, determining whether a Section 9 agreement is another option available. But you've got a couple of options. And again, the triggering age is adulthood.
Right. One question came in earlier, is, can an attorney be an executor?
Absolutely. And it's very common for people that are developing a power of attorney to appoint the same individual. So there really isn't a restriction other than the individual should be 19 years of age.
Excellent, thank you. A question from Karen. How can these agreements be transferred when those who are representing pass away?
So again, these documents are living documents. So whether it's a power of attorney or a representation agreement, when you die, they die as well. They have no longer any validity. When someone dies, the new document at that point is the will. The will then will take over the affairs of the individual. But again, a friendly reminder that these personal planning documents are living documents, and they are only in existence while you want them to be in existence. So if you have the capability, you can terminate these agreements. But if you do not, they will be in place until you die, or until, you know, there may be a court-appointed committee.
And last question, where might a microboard fit in all of this? Just individuals in the RA7 microboard could possibly end up as committee with the included expenses.
Yeah, the relationship of microboards and representatives and or attorneys is always a good question. And I know we had this question last week as well. I think the important thing to remember is that the role of the microboard is a much broader perspective. It really is typically intended to oversee funding from, you know, either a CLBC environment or a CECL independent living sort of environment. The microboard's responsibility is to manage those funds for the benefit of the person with the disability. The representative, and you know, has this sort of responsibility, at least under the Section 7 representation agreement, to really sort of support decision making around routine and financial affairs. So, you know, there's some interrelationship with the microboard, because there is this sort of dual sort of responsibility. And, you know, ideally I see an opportunity for a collaborative approach between a microboard and a Section 7 representative, where they work in conjunction, ultimately to, you know, benefit the needs of that individual and ensure that their wishes are being maintained.
That's great, Ken. Thank you so much. I did have a question, and I just want to acknowledge it came in very early in our presentation, wondering if you had any offices in Victoria. I see that you put your information on the slide here, so I apologize, I didn't copy and paste that, so I don't know who asked, but there is Ken and Audrey's contact information on this slide.
Yeah,
so once again, Ken, sorry,
I was just going to say we are based in downtown Vancouver. However, we have clients all over the province. In fact, we have them all over Canada, and so you know, we're always happy to hear from folks on the island or other parts of the province, and definitely, if we can assist, we're always open to hearing from prospective clients.
Well, thank you so much, Ken and Audrey. I am going to turn it back to my co-host, Bob Kasha, for final words, but on behalf of myself and FSI, I really appreciate this information. Bob, back to you.
Thanks, Karen. I'd just like to thank Ken and Audrey for this wonderful presentation. As usual, there's such a wealth of information that they have shared with us, and we will be sharing the presentation with all the participants. So if you have any more questions, feel free to write to us, and we might even get these answers back to you as and when we can get some responses. So thanks so much, Ken and Audrey, for being here again. And just like to say thank you from FSI for being here. And thanks to all the people who are attending. Look forward to seeing you at some of our other learning explorations that we are having at FSI. Please feel free to go in and register and attend any other topic that you might be interested in getting more information on. Thank you.